Our next panel is moderated by Ms. Angela Skow, Vice President of Construction in the South Central Region for CNA. She's going to lead a discussion on how to understand how third-party litigation funding is fueling some of the adverse results in our courts and what the industry could do to make change happen. I'm going to ask Angela in just a moment to introduce her panelists. Angela and CNA have been longtime supporters of our organization. They've been very generous with their time, talent, and treasure. And Angela, thank you for all your service to us over the many years, and we're anxious to hear what you have to share with us now. Introduce your panelists to us.
All right, thank you, Greg. So today I have with me Michelle Lester from Swinnerton Builders and Rob Ruszkowski, I knew I wouldn't do that, from Swinnerton, and then Seth Lamont from CNA and Andy Stabnick from CNA. And we're very happy to have them as panelists today. And one thing with this topic is we really want this to be educational and knowledge sharing. And people can say that this doesn't affect me, but it's going to affect all of us. I don't care if you're in construction, manufacturing, healthcare, it's going to affect all of us if we don't get a handle on this. So we're looking to make you aware of it, and then we would ask you to go back and share the information with your corporate people and see what you can do to help from the legal side on this. And so we're going to start out, see if I can run this slideshow. Okay. It's not coming up, Palmer. Oh, there. Okay. There it goes. Well, this was just a slide that said, wow, third-party litigation funding, but it's not working, so I'm going to skip past it. And then I'm going to turn it over to Michelle, and I'm going to ask Michelle to tell us a little bit about herself and Swinnerton, and then we'll go on and go through the rest of the panel.
Yeah, that sounds great. Thank you so much, Angela, and thank you, Greg, and thanks everybody for the opportunity to be here. I'm Michelle Luster. I'm the Director of Risk Management for Swinnerton Incorporated. Swinnerton was founded a little more than 135 years ago in California, but today we are a nationwide contractor and we have offices and projects in probably about 30 to 35 states. I'm looking at my partner Rob here to check me on that. Swinnerton is an employee-owned organization, and we've been employee-owned since the 80s. It was really a vision of the original ownership, which was the Swinnertons and the Wahlbergs, and that might be familiar to some of you who've been around a little bit longer, and they really wanted to make the organization something different, and so it's a really exciting company to be a part of. Swinnerton Incorporated, where Rob and I are employed, are the parent organization of Swinnerton Builders and many other entities that you might be more familiar with.
Okay, thank you. Rob?
And I am Rob Ruszkowski. I am a vice president with Swinnerton, and in addition to working with Michelle to help oversee risk management, I also oversee tax, treasury, sub-prequal, M&A, equity plans, and a few other fun things. So I got a few different things going on at any given time.
Seth Lamont, CNA. I am in government relations. I handle the Northeast of Mid-Atlantic and also take a lead role in legal reform and regulatory issues. I imagine most are familiar with CNA, but for those of you who might not be, we're a top commercial carrier. And I think of particular interest to this audience, construction is one of our major verticals where we've got a market position that's very significant within the industry at $1.7 billion in annual premium, thanks to a very strong underwriting team with leaders like Angela.
And I'm Andy Stabnick, Vice President in our claims organization, and I head up our staff counsel organization. We've got teams of lawyers across the United States, from California through Texas, Florida, up into the Northeast, and of course Chicago, where we defend CNA insureds in various types of litigation.
All right, thank you. Well, we're going to start out today with ladies first. Michelle, what is third-party litigation funding?
Maybe let's have a show of hands just from the room here. Who here has heard about third-party litigation funding? Show of hands. Okay. A few, yeah. So third-party litigation funding is a secretive, multi-billion-dollar industry. There are hedge funds, there are sovereign entities, and private investors who are basically investing in litigation interests for a financial outcome, their own financial outcome, not necessarily just they feel really bad for a Disney actor that's out of work. This is something that they're investing in because they are treating it like any other financial instrument that they can make this investment in.
Okay. All right, and I think you're speaking to the latest news story on
Might be.
Elon Musk. Okay. So what are different types, Rob, of litigation funding?
Yeah, so these investments can take on a few various forms. So the first one's going to be consumer, where you're basically, the funder is looking to invest in an individual plaintiff, right? It could be injury claim, it could be anything like that. Then it could also be a portfolio investment where it's not just a single plaintiff. The funder is really investing in the entire law firm in a basket of legal claims going on. And then there can also be investments into class actions as well as other types of issues.
Okay. And, you comment on investment. I mean, is this truly an investment or is it a loan to go forward? What?
I did use that term investment on purpose. So this really isn't a loan. It is, think of it as, I like to think of it almost as an equity investment, but I'm going to leave the term equity out for a moment. It's really a term to describe where you don't have a principle that you're going to necessarily come out. You are investing in a case or a group of cases where your outcome is going to be based on the outcome of the cases. So if the plaintiff, if you're invested on the plaintiff side, the plaintiff wins, you're going to get paid out. If the plaintiff does not win, you're not going to get paid out. So it's really a true type of investment with there's upside and there's downside.
Okay, thank you. And Seth, what does the footprint of legal funding industry look like?
So it's quite significant and fast growing. In the last 4 years, it's ramped up to $13 billion in invested assets and around $3 billion deployed. The current expectation is that by 2030, even following this 44% increase in the last 4 years, that it's going to grow to about the $30 billion range. So it's very significant. Certainly those that are pitching these investments are projecting growth annually in the 9 to 10% range, which is quite substantial. So it's growing very quickly and on a compounded basis.
Thank you. And Rob, go back to you. And on the funding you mentioned earlier, where's the greatest amount of capital deployed?
Yeah, it's a great question. So a survey in 2022 of large players in the space, 70% roughly of that capital was going into the portfolio context, which again is where they're investing in a group of cases, most likely a law firm in total. The GAO also confirmed that trend over the last 5 years or so. And I would say it's also worth noting that we've heard a little bit about these funders looking at the other side of the equation, so not the plaintiffs, but that seems to be pretty rare. It's really focused on the plaintiff side of the equation.
Okay, thank you. And I'm going to see if this will work. Let's see. Okay.
Litigation funding is a new type of investment that's become a multi-billion-dollar industry.
So these are all lawyers?
Indeed they are.
In essence, investors bet on the outcome of large lawsuits the way traders bet on stocks.
How often are you right?
We're right about 90% of the time, and we're wrong about 10% of the time.
The problem is this market is exploding with nearly no rules or oversight.
So 60 minutes. And Michelle, you know, when you see things like this and what we have to deal with and what's possibly coming on an even broader scale, can you elaborate on some of the issues caused by the presence of this mechanism in our system?
Well, I mean, to name the elephant in the room, the issue is that you don't really know who the parties are that you're dealing with in a lawsuit. Typically in a lawsuit, you're gonna have some idea of who the parties are that you either are being sued by or that you're pursuing if you're the plaintiff. But in this situation, these people are completely behind a smokescreen. And Angela mentioned awareness earlier. There's a real opportunity here for distortion of outcomes, because if you don't know who you're negotiating with, you can't possibly come to any kind of equitable resolution. I mentioned earlier when we were sort of preparing for this, a lot of times if you've been in a mediation, at some point in the mediation, you're not necessarily negotiating with the other party, you're negotiating with the mediator. But you at least know who you're negotiating with, right? In this situation, you don't know who you're negotiating with because you don't know who's pulling the levers behind that screen.
So, I mean, when you're looking at risk as a risk manager, I mean, how does this affect the way you look at your risk and the cost? The cost of construction, you know, it's going to be changed by the outcomes of where you're doing business. Can you give us some information?
Yeah, it's a terrific point, Angela. So as a construction company, we obviously rely really heavily on both our risk practices. Being an employee-owned organization goes a heck of a long way to making sure that everybody in the company is invested toward the best possible outcome for our clients and for our folks, you know, who work with us. In addition to that, though, you have to rely on insurance policies, right? That's your risk financing mechanism for when things don't go as planned. And so it's really difficult to conceive how you could possibly prepare enough for an outcome like this that, again, is completely behind the scenes if you don't have the ability to really penetrate that veil and understand who your opponent might be and how well funded they might be. You might be thinking about, you know, the way that you're going to come up with a potential maximum loss target for a given venue, right? For personal injuries or even for construction defect issues in residential construction, which I know you don't have a lot of here, but we have a lot of it, so I'm going to talk about it fairly. I mean, you have to be able to predict for those, right, and fund for them appropriately. And as a contractor, you got to price your risk, the whole risk. And it's really difficult to get your arms around this. And so we have to take a hard look at the venues where this is going to become an issue.
Mm-hmm. And with the owners in the room, I mean, they're all here because they're owners who do construction and have a lot of construction management going on. And so your cost of risk is going to, or your cost
our
of
cost
business.
Of risk.
It
it's
is.
Our cost of risk.
It's everybody's cost.
Yeah.
And, you know, you look at the nuclear verdicts that are out there, I mean, $33 million for one in California. Then you have the verdict in Texas for over $800 million for a developer. I mean, how do you really get your arms around that, and how do you fund for that? And for large corporations, you can build towers, but for smaller businesses, that will put them under. They will be gone and outside of your food chain for support and labor.
No, that's absolutely right. I mean, some of what goes into, you know, preparing for an event like this is to unfortunately refute what Sean said earlier. It's not sexy. It's chopping wood and carrying water. It's making sure that you've actually read your contract. It's making sure that your business partners read their contracts. It's doing what you actually say you're going to do in your plan when you have your, you know, risk financing and risk transfer methods of how you're going to get those things done, and reinforcing the importance of those things so that if in fact you do draw the black marble and you end up in a situation like this, you've at least done everything you possibly can to protect your organization, your clients, your subcontractor business partners from this potential outcome.
And I think given the agendas that we've talked about in the conference in the last couple days, mental health issues, opioid abuse, skilled workforce availability, training, all of these are things that we need to take into account when we're looking at our risk and trying to plan ahead. Are we controlling these issues? Are we doing the best we can at training to get the best outcomes? So.
No, I've got one more thing, and not to sound like a panic monger, but anybody who builds construction in New York knows the challenges that are embedded in the cost of construction in New York. You cannot ignore labor law. It's going to be there. You have to address it. You have to price it into your contracts. I don't want this issue to end up being a similar challenge that we all have to get across for building, right? It's enough of a challenge already. And so again, that's the reason why we want to create some awareness around it to try to eliminate the smoke screen.
Right. So let me move on to Andy. And I'm going to ask you, Andy, how can litigation funding be problematic in the context of a particular case? So if you were unfortunate enough, Michelle, to have one, can you expand on that?
Absolutely. So I'll start off first with just that element of transparency. So we don't know when there is a litigation funder behind the scenes in every case. And that's what you'll hear as a theme coming out of this. Disclosure. We're seeking disclosure. We want to find out whether it in fact exists behind the scenes so we can know the drivers behind a particular piece of litigation. And when I thought about this question, I thought about the old days 20 plus years ago when I was a trial lawyer defending insureds, and we'd go into a settlement conference. We'd be in front of a judge, in front of a mediator, and we'd start talking. We'd talk about the case, talk about liability, but eventually it gets to the numbers, and you start talking numbers, and you start talking what dollar number do I need to put into your client's pocket? What do they need to walk away with to resolve this and be done with this litigation? In litigation, third-party litigation funding, we don't know what's ultimately going to go into that plaintiff's pocket. So seemingly put forth good, solid offers, rejected, because behind the scenes, they know that they've taken X amount of dollars from a funder, and they've got to pay back twice that. So they can't resolve these cases. And when I think, take a step back and you say, well, that happens in other contexts. You have workers' comp liens. You have a lien, and but there's disclosure there. So we ultimately know that plaintiff's got to put X amount of dollars has to go back to the comp carrier. This amount's going to go to the lawyer. This amount's go into the pocket of the plaintiff. But in the third-party litigation funding, we don't know. So that's where you'll hear from us, you'll hear from me in the litigation context, why it's important to ask and push for it. And then from the legislative side, we want to seek greater disclosure of this so we know who we're litigating against. And I think from a broader perspective, when we think about litigation and litigation funding, it's incredibly expensive for the plaintiffs themselves. Because they will take, in the few examples that we have where this has been uncovered, you see these instances where plaintiffs have taken X amount of dollars in the consumer funding situation. They need some money to live on during the pendency of their lawsuit. So they'll take $10,000, and then ultimately 3 years later, they owe $50,000 back to the funder. And they've lost that $10,000, that's gone. That went for rent, went for whatever they needed, and now they've got to pay back this. So they can't settle for a reasonable number. They've got to turn around and roll the dice. And these massive litigation funding entities, they're willing to roll the dice. They're willing to do that. So it can be problematic, and it can cost more in litigation. When we think about defending cases, it's going to take longer. The longer cases sit around, the more expensive they are, the more work we need to do on the defense side to try and pick and get somebody to disclose it in depositions, in discovery. So all in all, it has those negative impacts.
So, and don't the funders claim that they do not exercise control over the plaintiff?
They do. They do. They do. They, of course, say, listen, we look at it. You saw some of the lawyers all sitting in their cubes looking at the portfolios of these plaintiffs' lawyers, and they'll say, you know, we make an honest investment. We step back and just wait for the returns to roll in. And as he said, 90% success rate. And so they do. They have said that. And fortunately for us, you know, through some limited disclosure that's occurred, it's happened in a few courts around the country. We've gotten our hold of some of these agreements, and they have shown some provisions in there that do have some power to control, power to reject settlements. So, you know, it's just the tip of the iceberg, but certainly it flies in the face a little bit of some of those grandiose claims that they make in order to justify their business model.
It's really hard to imagine, I have to say, that they would achieve a 90% success rate unless they have some kind of control over the outcome. Nobody's that good.
Right. And you just think about these examples where you have, you know, someone who is facing down, I owe this funder X amount of dollars. Are they exerting control? No, but implicitly, they know they can't resolve the case. They can't walk away. They may be done with litigating. They don't want to be deposed. They don't want to go to trial. They want this, you know, to move past this, but ultimately they can't because they're staring down that what they owe to the funder. So, kind of an implicit control that occurs with the investment of those kinds of dollars.
Yeah, and part of the playbook on the front end is they achieve the 90% success rate, not only because of the leverage they create, but also because of the cases they select. So they'll say, we need a 45, 50% interest rate on this because a certain percentage of the cases fail. But the reality is they hire very seasoned defense lawyers, and you know, Andy and his team at CNA, you know, I've talked to him about this before. I mean, seasoned defense lawyers have a pretty good idea what a case is worth when it comes through the door. I mean, they certainly know whether it's meritorious. So this idea that a significant number of the cases are failing, and therefore that's why they need this exorbitant rate is a bit of a red herring. And you heard from the leader of Burford say, we have a 90% success rate. So they kind of want to have it both ways. They want to say 90% success rate to the investors and then tell policymakers that they have a low hit rate in terms of not regulating their interest rate.
Yeah, I mean, it kind of occurs to me as we're talking about this that the way, if they're going to fund a portfolio of cases, so at like the law firm level, maybe they're not exerting control over any existing of those cases, or maybe there's some, but not explicit. There's still going to be power over that law firm, I would expect, that they're only going to take certain cases. They're going to take those cases that are going to get to the 90%, and there's a bunch that they wouldn't even take on because it's not going to meet the funder's threshold.
Yeah, and that's a massive ethical issue that's been discussed, where you have a third-party litigation funding firm or other entity that's exerting undue influence over the practice of law, because historically the practice of law was conducted by lawyers who are bar admitted versus having this economic interest over the top telling them which cases they're going to prosecute, which cases they're going to settle, and so on and so forth.
Without any ethical consequences.
Correct. Yeah, they're not regulated by the bar. I mean, litigation funders aren't. It's part of the reason why they don't want to be disclosed.
Right.
Right.
I think also, if I could just, you know, and when we talk about impact, and while it's not, you know, we don't know yet, and you know, a correlation does not equal causation. However, you know, we hear about nuclear verdicts. We hear about the value of cases just going up and up and up. Well, you have these scenarios where people are, you know, not settling and frankly rolling that dice and building those cases that they throw in front of juries in particular venues around the country, and we know where those judicial hellholes are, and they are ringing the bell with those $100 million verdicts, $500 million verdicts, $1 billion verdicts. And I think we cannot ignore the fact that you know, the idea of these nuclear verdicts are there and real, and this could be a contributing factor to it.
So thank you for that. Do you have any war stories you could share with us? Any additional?
Well, let me think. War stories. I talked about that one. You want me to talk a little bit about the Burford scenario? So you did see the head of Burford on there, and you know, he expresses in the, I actually recommend Googling 60 Minutes and third-party litigation. It's about a 13-minute clip, and it's a very, very interesting read with both an example of a consumer-funded case as well as a commercial case. In the commercial case, I'll talk a little bit about a different one, but it involves Cisco, and it's going on as we speak, but Cisco, the food services company, decided, hey, we're going to bring a lawsuit against some of our providers for price fixing. And they frankly didn't want to fund the lawsuit themselves, so evidently went off to Burford and got roughly $140 million in funding in order to fund that litigation. As the litigation proceeded, they ultimately wanted to resolve the cases. And Burford stepped in, went into an arbitration in New York, and got a temporary restraining order, keeping them from settling out their cases. And suddenly that just
They're the actual party.
Correct. And that threw the you know, talk about pulling back the curtain. That pulled back the curtain on this relationship. And ultimately, Cisco then brought suit against Burford, and actually their own lawyers as well, and accused them of you know, stepping into their dealing in that underlying litigation. So in that scenario, we were able to see that in fact that agreement between Burford and Cisco did have some ability to control the litigation, control settlements, et cetera. And that litigation is ongoing as we speak.
Okay, that's pretty scary.
Yeah.
So Seth, let me ask you this. What other types of cases are affected by investments in lawsuits? It assumes, you know, as Andy was talking, you know, consumer class actions would be area ripe for funder investment, but what do we know about other abuses in this context?
So both class actions and patent cases, and it's an interesting scenario where the funders are involved in this multifaceted way. So for instance, in the context of class action lawsuits, the funders are actually pushing out the advertising. They're funding the advertising, they're intimately involved, they're involved in the advertising strategy, they're helping manage the aggregation of plaintiffs, which of course brings about all the settlement leverage. And as probably many, if not all of you know, that aggregation causes settlement leverage because of the cost of investigating individual claims that have been aggregated in the hundreds of claims or thousands of claims. In the context of class actions, there's also patent lawsuits that are completely trumped up by the plaintiffs' firms and the lenders actually creating shell companies to buy patents with the express purpose of bringing lawsuits. That particular piece of litigation might not be the most significant, perhaps, on a day-to-day basis for maybe the construction business, but the issue there is national security. Because in the context of patent litigation, sovereign wealth funds, the Chinese, the Saudis, et cetera, but probably mostly the Chinese, there's a thought that they're gaining trade secrets, and B, in the context of defense contractors, potentially sensitive information from a national defense perspective. So there's just layers and layers of issues that are caused by the presence of this funding.
And so far, you know, have we had more? I think one senator wrote a letter to the Chief Justice about this. Has there been any other action across the
Yeah, so Senator Kennedy, thanks for asking that. So Senator Kennedy of Louisiana wrote a letter to Attorney General Garland asking, for the Attorney General to be an advocate on this issue at the national level. He's also introduced a bill that would prohibit sovereign wealth funds from investing in entities that loan monies for U.S. litigation. There was a hearing in the fall on the issue. I can't say that it's on the fast track, from a national perspective, but we're heading in that direction. I mean, we've got in the context of the patent litigation, the Delaware courts issued a rule that TPLF has to be disclosed. New Jersey did a court rule as well. The court in California, in the context of a class action suit there, forced disclosure in the context of an individual suit. All this helps put pressure on the U.S. Supreme Court to adopt rules forcing disclosure, which they've been slow to do, but it seems to be heading in that direction.
And when you think about funders, and they'll say, everything we do is wonderful, and we're the white hats, and we even the playing field. When you think about that disclosure element that we're seeking, when that chief judge in Delaware, in the Delaware U.S. District Court, put forth his requirement of disclosure, they saw the filings of patent litigation in Delaware federal court drop precipitously. So use whatever sense of logic you want to hear, but they decided to seek their cases, seek to prosecute their cases elsewhere where there wasn't such required disclosure.
Okay. And let me go back and ask on this. This is obviously an issue in terms of reforms, and is there any other advancements that we've made on a national disclosure basis?
So we've worked with the American Property Casualty Association, the U.S. Chamber Institute for Legal Reform, the American Tort Reform Association, and a whole host of state-based groups. Wisconsin does have a disclosure law. It's been on the books for a few years. Our most recent successes have been in Indiana and Montana. We're looking to build on that. We've got a dozen states we're targeting for this legislative session. Most recently, I think it was Monday of this week, Georgia introduced a bill that would require disclosure. And of course, to build on Andy's comments about asking for disclosure as a part of discovery, the reason it would be good to have disclosure as a matter of right and as a matter of course is it gets us out of any of this discussion of relevance. And certainly when Andy mentioned workers' comp liens and the like, it just makes sense. I mean, to the extent that we have to disclose our policy limits and they're not admitted into court, why wouldn't other third-party financial arrangements also be disclosed, regardless of whether they're admitted into court?
So, and judges, are they aware, not aware? Can they do anything about that?
I mean, in terms of, do you want to take that first?
Sure. Yeah. I'm chomping at the bit to do that. Yes, because when we're talking about awareness, we need to make judges aware. We need to make all of you aware of this so you can talk to your own defense counsel about it. But you figure out different ways to attack it, and ultimately we want that disclosure. And they will fight, and they have fought across the country. Number one, it's irrelevant. Don't need to disclose it at all. Number two, if you start to get disclosures, very limited, and they throw up roadblocks. You want to throw up attorney-client privilege. You want to throw up attorney work product. All those barriers. And we turn around then and, with some limited success, is arguing around even judicial ethics. The fact that judges need to know who is seemingly in their courtroom litigating cases. Whether they have some financial interest, they need to know so they can recuse themselves. So we try to use, be as creative as the plaintiff's bar when it comes to arguments around why this should be disclosed. And when I think about all of you, I think about, a responsibility that I have sitting here is trying to make you all better clients. In the event, hope you don't, but in the event you get sued, making you a better client in conversations with your counsel and conversations with your law departments, bringing this to the forefront so they know about it and they're aware. The law is evolving quickly and it varies across state jurisdictions, even federal courts, until we have some kind of uniform disclosure requirements. So you've got to be aware of where you're sitting and ask those questions of your counsel. What are you doing to go about trying to discern whether in fact it exists? Are you asking very pointed questions? In discovery, you can't have your lawyers just ask these broad-based, tell me, anybody and anything that has any interest in whatsoever. They're going to object overbroad, and a judge without any other inkling or rationale will agree, sustained, move on. You've got to be very pointed. You've got to ask for those contracts. You've got to ask for them. And part of your disclosure can be take out your work product, redact it. We just want to know that it exists. And once you know that, then you can start to formulate a different litigation strategy, knowing that you've got a new player within the confines of your case. Again, so it comes back to that awareness element. It's
I wonder,
crucial.
Andy, if there's any information out there about when those disclosures are forced, when the hand is forced, what that does to their level of interest in a case once they've had to come out behind the curtain.
Not necessarily.
Certainly the patent litigation that you talked about
okay.
in Delaware, but I don't know if there's anything else out there if people are successfully getting this information as a part of discovery.
So you can, there are articles published. The U.S. Chamber of Commerce has come forth with kind of a playbook. And if anybody's interested in it, connect with us. We can send it to you. But it's got a very tactical playbook when it comes to how to seek this information in litigation. And it's got examples of, it comes down to having examples of motions that have been successful, memorandum of law. While they may not be applicable to your various jurisdictions, you can use that as that springboard to start that conversation. So that is a truly helpful document at your disposal right now.
And thank you. And Michelle, I'll ask you, earlier you commented on having good contracts. What are other things that you feel like you can do to keep your cases out of this type of situation?
It's a really good question. I mean, a big part of it is awareness amongst the, again, largely defense community, making sure that defense attorneys have got their spidey sense up, looking for situations where it seems like, gosh, this case ought to be resolvable. It seems like we really don't have any conflicts yet to talk about, and yet they're still not willing to mediate or arbitrate or what have you. Making sure that your counsel is staying on top of those things, and then making sure that you get those opportunities to force the issue into the foreground by asking the right questions, by bringing it to the attention of, be it the judge or the mediator or the arbitrator, whoever it is, to really lay it out there on the table and say, I think we've got an issue here where there's some parties involved that are not sitting at the table or in a separate room negotiating this.
Okay. So if, I'm going to go back to Rob on this one. Mm-hmm. So for people who disfavor this practice, I won't say everybody does, obviously, because some are profiting off of it. How can you most effectively avoid by indirectly investing in this type of portfolio?
I'm so glad that you asked that question, and it's a really hard question because there's not a really good answer for this. I mean, really it comes down to whether you're an individual or you're investing on behalf of your company. It really comes down to reviewing the investments that you're in. So not only, hey, I'm invested in a hedge fund and they're doing what they're doing, but going down layers. There's layers of this, right? You could be invested in a fund. That fund is invested in an entity or a fund. And it could even be you're invested in a company, but that company holds investments as well. So there's many, many layers of it. And it's not going to be necessarily obvious to find it out. You're going to have to look at your statements that you have and figure out what, if anything, you can find out about it. And to me, it really becomes an issue. I mean, let's say you're the CEO of a company and you're invested in some kind of a fund. It could be a hedge fund. It could be some other kind of fund. And that fund is invested in one of these companies that will fund these types of cases. And one of the cases they're looking at is with your company, and they're suing your company. So now you have a real conflict that you don't even know that you have. And if that came out, it could not be a great fact to see out in the public light. Again, even though you really don't know, because it's hard to find out. So it's a really important question and goes to a lot of what we're talking about here is to shine a little bit more of a spotlight on this entire practice.
I would agree. I mean, if it's such a valuable practice and if the industry really needs it, it seems like they wouldn't really mind having a little bit more visibility.
Disclosure.
But it does beg the question.
Yes, yeah. I mean, that would be a good headline, right, for somebody if, you know, you were investing in suing your own company.
Right.
So, okay.
Ask Pete Rose.
Talk about shock and awe, right? Okay, so are there any other things you guys would like to bring to the light before we wrap it up with Seth and ask him what we can expect in years to come? Go ahead, Andy.
I would say just on the investment side too, I was fascinated. So there's a couple of these entities that are publicly traded. And so I, poked around on their website, got into their investor relations site, and I was fascinated to see some of the large entities, teachers, pension funds investing in these kinds of these companies, but know that for the few publicly traded, there are many more privately held companies that do this. So we know of their existence, but we don't know much about what's happening behind the scenes, and we don't know what their ethical, feelings are towards this. You'll hear from, the spokespersons for the industry. You'll hear from them. We are the white hats. We level the playing ground against these huge insurance companies or huge corporate defendants. We make it viable for people to bring meritorious claims. They need to control that narrative. They need to control that and come across like that. And we believe, and I think we all should, we'll get on board with that idea of disclosure and transparency. If in fact this is the case, then you shouldn't be afraid of just showing what you're doing. Giving us the basic parameters of how you are funding these and how this is impactful to these plaintiffs, be they a single personal injury plaintiff, or it's a portfolio of one plaintiff's law firm's cases, or in a commercial environment. So that's something I thought too would be important to raise to the group.
All right, thank you. So Seth, we're wrapping it up here. So any good things we can expect in the future?
Well, I think it's certainly not going to be overnight, and it's going to be difficult to predict when we'll achieve it, but I do think we'll achieve transparency here. It's going to be more difficult in the portfolio context, of course. That's where a funder funds 100 cases for a law firm, and it'll be more difficult to get the disclosure in the individual case, but we've had some success in a few state legislatures, as I mentioned. We're just attacking it from a number of angles. So we've got, there's a petition pending before the U.S. Supreme Court to change the federal rules to call for disclosure. We also have similar petitions pending in New Jersey, Florida, and Texas. So we're attacking it from a number of angles. And I do think we'll get there. The thing that's really frustrating, I think, from a public policy perspective is, generally transparency has been a winner in public policy making, right? You think, who could be against that? And usually when a legislature or a policymaker doesn't really want to make any substantive change, they usually pivot to transparency. And the headwinds we've faced in getting transparency here is really indicative of the political influence, frankly, of the plaintiffs' bar that's been involved and the funders. That's the challenge. I think the reason to be more optimistic, I think, is that it depends on who you talk to, right? But I mean, there are polls where as much as 85% of people, would support disclosure, particularly where they know that there's a foreign entity involved in funding. That number drops maybe 10 points when, it's just a general question of, would you support transparency? And also among the legal community, there's also an interest. There was a Bloomberg Law poll where it was 46% of lawyers supported disclosure, and then, another bunch were neutral, and only a small proportion oppose the idea of disclosure. So it seems the mass majority of people support disclosure, and I think we'll get there, but it's certainly not going to be overnight. It's going to be a long war with a number of battles. I mean, Louisiana is a perfect example where we got a bill passed last year, and it was vetoed by the governor. We'll be back and pass it again as our adversaries do theirs when we get theirs vetoed.
Okay, thank you. So, in wrapping it up for the group, thank you to all the panelists. And all of these, this is their first time at CURT. So, and I want to thank everybody here for welcoming them and showing them a good time. And if we have any questions, Greg.
Yes, we sure do.
Okay.
First of all, let's give it up for Angela and company.
Good job, girl.
And actually, there's been quite a few questions come in, if you can see here, Angela. So let's just start. Does this type of business model perpetuate litigation? And if so, how?
I think it absolutely does.
Yes.
Both in,
kinds of returns.
in volume and in length of case. So when we talked about, the portfolio funding, the idea of ultimately a firm getting X amount of dollars in a non-recourse loan that's looking at their book of business, and they can use that money for whatever they want. And ultimately, they're going to try to drum up more business. Seth talked about it in the class action space. We've all seen those ads on the TV. If you've been, impacted by X, call this number. So they're advertising. They're trying to get, broaden their plaintiff pool in those cases. But it feeds right into, they'll tell you it's operating expenses, et cetera, for these plaintiffs' law firms. But I tell you what, and I'm in Connecticut, so not one of the true judicial hotspots, but the number of billboards I've seen with plaintiffs' lawyers on there now, as I drive to and from work through Hartford, it's amazing. Mm-hmm. So I think, I believe without any, truly anecdotal, but some of that is certainly expanding litigation, because it's driving those plaintiffs' lawyers to expand their marketing efforts, because they've seen the success of the big hitters that we've seen across the country that I'm sure probably everyone in this room has had one or two cases with. So I think, yes, in the number of cases, absolutely. And then in the length, we talked about that. It drives longer litigation, more difficult to settle, and ultimately we go to trial, and that costs more. That costs more from a pure defense counsel perspective, but then it also drives more jury awards.
So just a few more seconds on that. Sure. To illustrate, in portfolio funding, let's say a firm has 100 cases, 75 of them are meritorious, 25% of them could be, considered specious, or meritless. The portfolio funding buoys that other 25% that might otherwise flatline if the firm wasn't funded.
Yep.
Interesting. So somebody mentioned the, quote, judicial hellholes in the country. Where are those?
Illinois.
Well, let me see. New York City. And I'm going to say the city, because I'm going to say all 5 boroughs. Richmond County, Staten Island, you're okay. But I'll tell you, so it's Manhattan, Bronx, Brooklyn, and Queens. Cook County, Illinois. We've got spots in Texas, predominantly East Texas, Beaumont, Texas. I'll give you the whole state of Florida. No, I'll tell you, South Florida, Los Angeles, around there. What else am I missing?
Well, Florida's going to approve. I think that
Yes, true.
generally where you think they are, but the real emerging one is Georgia, and it's predominantly because of the Ford rollover case with the extraordinary verdict there. But by and large, where you think they are, except Georgia is the real.
And Georgia's
real
had some
hotspot.
wage and hour issues that have come
Oh,
up
yeah.
recently that have contributed to some of that, I would say. I mean, we've certainly seen that from a contractor perspective.
Well, and the success in our success in legal reform in Florida has seen legal abuses migrate up 95 into Georgia and the Carolinas.
And
Quite literally.
Judicial hellholes is, it's a published document.
Right,
So
that's what I
again,
was gonna say.
if you're interested,
That's not just Andy's opinion.
no, exactly.
No,
There is
Google it, right?
far more data behind it, and it's updated every year. So if you're interested, reach out, and we can get you a copy of that as well.
Are there any unintended consequences for fighting this initiative?
It's a good question. We actually debated about this a little bit when we were preparing for our panel. Like, are we unintentionally eliminating an opportunity for the little guy in quotation marks, from really pursuing a case that they ought to have the opportunity to pursue? And I suppose there's the possibility for that, right? Rob did talk about it.
Yeah, I mean, there is the concept of altruism here. In concept, why would it be bad if someone was wronged, someone was hurt, that there's a party that's going to come in and help them get the appropriate judgment? In theory, makes sense, but we've talked about all the issues. So I mean, it is a real question. But I think that the benefits of disclosure and going down this route outweigh the cons.
Yeah, I mean, why does somebody need to be behind a curtain to make those kinds of investments? If it's a valid claim, then there's no reason why they shouldn't be disclosed, just like the workers' comp lien that Andy mentioned.
Yeah, so with transparency as the remedy, I'd say no. If we were talking about a prohibition or a low interest rate or some other barrier that made it destroyed the economic viability of the lending business, then perhaps, but disclosure falls well short of that. So if I had a one-word answer, it would be no.
And we haven't really talked about fees and how the fees are structured, and it's hard to know exactly what that is. But I think it's fair to say that in any other context, this would be considered predatory because it is pretty hot. That oftentimes the funder will get paid out half of the net proceeds. There could be a multiple of the investment. There could be kind of juice, if you will, like an interest on the invested funds that has to be paid first. So there's a lot of components to how the funders get paid, which leaves the plaintiffs with less.
Yeah, I think juice is a good description because I think some of the
Big,
some of the economic terms would literally probably offend payday lenders, or pawn shops. I mean, they're extraordinarily high. Some of them have been seen to be as much as 100% annual because the way they compound.
One final question. We really don't have time for all of them, so you can see these folks at lunchtime, but what can an owner's organization like CURT or CII that has no legislative initiative do about this?
I think, and I'll take that. I think, encourage the membership, and I'll encourage those of you who are involved here. I mean, talk to your legislatures, get involved in state chambers of commerce, state-based legal reform groups. Certainly, this group could get involved with the U.S. Chamber Institute for Legal Reform. To the extent that you don't have your own political shop, certainly coordinate with us and participate on a grassroots and grass tops basis. Grass tops meaning, of course, the leaders in your industry.
And I mean, continue to provide opportunities like this for us to share awareness about the topic. Thank you for that.
Great. Yeah, you're very welcome, and we could probably do something in our Voice magazine and subsequent issue, which would be great. And Rana, if you're in the room, we'll work with Angela to coordinate that with her team. And with that, let's show our appreciation to Angela and Company. Very good presentation.
Thank you.
Terrific.